आपको बराह रास्त लिए चलते हैं। सुप्रीम कोर्ट में बराह रास्त समाअत जारी है।
And if your lordship may see the opening paragraph by my lord Mr. Justice Syed Mansoor Ali Shah, I raised the following question during the hearing of this case on 18th August. Whether this bench should continue hearing this case, or should this case be adjourned till the court first decides the constitutionality of the Supreme Court Practice and Procedure Act 2023, or in the alternate, should a full court hear this case pending decision on constitutionality of this court. Then His Lordship gives the reasons what transpired that day. Paragraph 5, His Lordship refers to my submission. The Learned Counsel for the Federation has argued in favor of adjourning the hearing of the present case till decision on the constitutionality of the Act, or in the alternate, constituting a full court bench to hear it, mostly for the same reasons as recorded in my last order and reiterated above, and no satisfactory answer has been put forth by the Learned Counsel for the petitioner to the proposition recorded therein, that if ultimately the court upholds the constitutional validity of the Act, any decision given in the present case by this bench, which is not constituted as per the procedure prescribed in the Act, and of the strength of judges required under the Act, may arguably be quorum non juris, and thus a nullity in the eye of law. The order of my learned brothers, I submit, most respectfully does not address this concern either. Even they note in their order that it would clearly be presumptuous of us to assume the outcome of the above issue. The decision of the constitutional validity of the Act is an equally possible decision with that of its constitutional invalidity. It is not a presumption or speculation. No one can be sure of either of the decisions before pronouncement of the same by the bench concerned. Further, it is not the matter of compliance or non-compliance of the interim order passed by the 8-member bench, which is only of temporary nature. The real concern is the effect of the possible final outcome of the constitutional validity of the Act on the present proceedings and any decision given therein. There is a possibility that the instant proceedings and the decision given therein may become quorum non juris and a nullity in the eye of law if the constitutionality of sections 3 and 4 of the Act is upheld by the other bench. So this Damocles sword hanging over these proceedings can easily be removed if either we await the decision of the 8-member bench on the constitutionality of the Act, or make it ineffective by placing the matter before a full court bench. The interim order of the 8-member bench suspending the Act was passed on 13th April 2023, more than 4 months ago, and there is no next date of hearing fixed in the case. This unnecessary delay in adjudicating a matter which directly deals with the core functioning of this court is not understandable, considering that almost 50 hearings have been held in the instant case. It therefore doubly requires that the constitutionality of the Act be decided first as the earliest, so that the court can function in accordance with law rather than under the uncertainty of a stay order. I therefore maintain my earlier view in my note of 22nd June 2023.
What was your ground for constitution of larger bench or for staying the proceedings?
My lord,
your ground, what on which?
My lord, section 3 and 4 of the Practice and Procedure Act.
4 talks about interpretation of constitution, whether any constitutional interpretation was required in this case?
Yes, my lord, because they were asking for the striking down of several procedures, provisions of the NAB Amendment Act. There was on the touchstone of the Constitution. The argument being made was that it violates a number of provisions of the Constitution, the provisions relating to fundamental rights, provision relating to Islamic provisions, provisions relating to power of and authority of Parliament, provisions relating to virtually how a power is to be exercised. All of those were in question.
There's also another ground, speaking for myself,
my lord,
where a larger bench should have heard this case, and that was the question of maintainability, because in high courts certain petitions were pending challenging the Wairis, and the judgment of the majority did refer to the Benazir Bhutto's case, PLD 1988, Supreme Court 416, which is, I believe, an 11-member bench.
My lord.
and that is the law till today.
My lord.
And again, this court is ignoring that law. So either that was binding and had to be followed, so any departure that was required to be made had to be heard by a larger bench.
My lord,
so that is...
May I respectfully am very grateful for that observation. I had spent an entire day arguing Manzoor Ilahi and arguing on the basis of Benazir Bhutto and pointing out that there was a petition pending under Article 199 of the Constitution before the Islamabad High Court, and in view of the pendency of that petition and in view of these two judgments...
You see, regardless of that, Makhdoom Saab, with great respect, the larger bench judgment is binding even on this bench, because that's an 11-member bench.
Yes, my lord.
And Manzoor Ilahi's case has been reaffirmed by them.
Yes,
and that is the law.
Yes,
and that law is again and again ignored.
Yes,
and that was also ignored in the election matter, to which the majority has made a reference.
My lord, yes.
So that could not have been overruled, and till that is not overruled, 184(3) petitions are not maintainable if matters are pending before the high courts.
My lord, even before the Practice and Procedure Act was enacted, that was a submission made by me before the Honorable 3-member bench of this Honorable Court, and that was my next point, which your Lordships has encapsulated far better than I could.
Arguments, we will hear you later. This is your main arguments.
My lord, that's my second argument after the Practice and Procedure Act. So, the second argument...
What is the first?
My lord, the first was that in view...
What is the first proposition?
The first proposition is that in view of the provisions of the Practice and Procedure Act 2023, the proceedings before this Honorable Court's 3-member bench had become quorum non judice, and the matter should have been referred to a committee.
No. So are you saying this judgment is a nullity in law?
That's what I am submitting, my lord.
What do you say about when the Practice and Procedure Act was suspended? It was not in field.
My lord, your Lordships knows it better than me that an order of stay operates inter partes. It operated between them, and my lord, Mr. Justice Syed Mansoor Ali Shah refers to my submission and encapsulates this very well, that if tomorrow this Practice and Procedure Act will be upheld, the stay order will be vacated, and for that period...
But so you were prescient, or was Justice Shah prescient?
My lord, this
or both of you?
The members of this honorable bench are always prescient.
Makhdoom Saab, speaking for myself, the petition was not maintainable in the light of the law laid down by the Benazir Bhutto's case.
My lord, and that was my submission even prior to the 2023 Act, because the Act came in between.
चलिए ये एक proposition हो गया. अगला proposition.
Sir, अगला proposition ये है कि on the same issue, a constitution petition under Article 199 of the Constitution, being petition number 2557 of 2022, challenging the vires of the law, was pending before the Islamabad.
So I'm just thinking aloud, don't read too much into my observations. It could be that a petition comes here and someone, just to stop that, files a petition in the High Court. Okay, it could be completely mala fide. Okay, how would we know it? We can't know mala fides and bona fides, and that will happen. So should that not be a matter of case-to-case basis, just because a petition has been filed? Or, for instance, some things are time-related. Like, you know, it's very important something happens and a party is not interested in adhering to a certain time. Let's take elections, for instance. So they file a petition, one in Balochistan, one in Sindh, etc., and someone files who's actually interested in elections in the Supreme Court. So the Supreme Court should say, hang on, let's wait those. But they will effectively get the relief what they wanted, delay. So should it be binding on us to that extent, or we have to actually consider the merits of each case, whether in this matter we should await the decision of the High Court? No, the heavens won't fall, we can easily await it. In some other matter, no. we must proceed immediately and decide it?
My Lord,
or is there a hard and fast rule we have to follow?
No, my Lord, even in Benazir Bhutto's case...
We want to hear your view.
No, may I just point out what this Honorable Court has observed? In Benazir Bhutto's case, their lordships described the principles in Manzoor Ilahi as the salutary principle, but in the facts and circumstances of the case, did not follow that route, did not pursue the route. They created a distinction. So what your lordship is observing, your lordship will look at the facts of the case, but over here, it was not a case where to divert the proceedings from this Honorable Court to the Islamabad High Court, this petition was filed. The Islamabad petition had predated this. That petition was filed by the Islamabad High Court Bar Association. It was not filed by any surrogate petitioner, and it was pending the hearing, and that objection was raised at the very first stage before this Honorable Court that the Benazir Bhutto's case applies.
Benazir Bhutto, we're talking about the election matter.
Benazir, no, my lord,
which Benazir Bhutto?
My lord, the political party's case, the first case, that is 1988 Supreme Court 416.
Halim Saab wala faisalah.
Yes, my lord.
My lord has rightly pointed out and very eloquently in Benazir Bhutto's case, these concerns have also been addressed.
Yes, my lord.
And addressed at length and very eloquently.
Yes, my lord.
That when a petition under 184(3) will not be taken up.
Yes, my lord. Yes, my lord. And their lordships in that case, as your lordship knows by your lordship's detailed reading of the judgment, have evolved the doctrine of effective pendency. That if what the High Court was doing was virtually not proceeding with the case and virtually frustrating those proceedings, then not proceeding in the Supreme Court would not be countenanced by this Honorable Court. It was submitted that that was not the case over here. To the contrary, after filing the petition in this Honorable Court, adjournments were being obtained from the Islamabad High Court that now that we have gone to the Supreme Court, please don't proceed over here. So it was an altogether different situation, and that is why it was relied upon.
Let me clarify one thing from you. If, there's a big if, capitalized big if, we accept for the sake of argument, don't think we have, this quorum non judice. Are you just relying on that ground and then the petition in Islamabad High Court gets revived and we just stop?
My lord,
or are you also going on the merits?
My lord, I would, as a council does, I would raise these 2 or 3 preliminary submissions, and I would also show to your lordship that even on merits the petition was not maintainable, and I will identify them also in one-liners before your lordship. My lord, besides this second submission, the third one was that this was a unique case in the common law history of constitutional countries. There is no similar case, and I had made that submission and the counsel for the petitioner did not come up with a case. My submission was that this was the first case of its kind where the petitioner in the petition itself, the petitioner himself had said that he himself had passed this law through various ordinances. And much of what had happened in the 2022 Act was incorporating what he had done through ordinances.
Are those ordinances on record?
Those ordinances were on record.
Are on record.
And
yes,
maybe the petitioner has realized that those ordinances were not proper.
And
maybe it has realized subsequently.
My lord, that is what he submits. That is what he submits, and that's why I'm saying that therefore his antecedents became a matter for consideration before this honorable court, that can a petitioner...
Yeah, but where is this admission?
Lord,
it is also mentioned in the judgment of...
Yes, my lord, but if your lordship will...
majority judgment, but they haven't gone beyond that.
Yes, my lord.
They've said that since that is no more a law, therefore they didn't consider it.
My lord, if your lordship may see it in the words of the petitioner himself, it is in part 1 of your lordship's intra-court appeal paper book, in paragraph 6 on page 121. Paragraph 6, page 121, part 1.
Padiye.
My lord, that apart from the aforementioned amendments, there were certain amendments introduced in the NAO 1999 during the period when the PTI government was in power, but these had not been converted into an act as the efficacy and propriety thereof was being reviewed. However, before any final decision could be taken in respect of the said amendments which were introduced through two presidential ordinances, that is Ordinance number 23 of 2021 and Ordinance 26 of 2021, the government regime changed as noted above. Be that as it may, the incumbent government has retained these amendments with retrospective effect and subtle changes of expression, which too are being assailed in the instant petition as being ultra vires the Constitution.
Who has drafted this?
Khaja Haris, sir. The council.
Isn't this a remarkable argument?
That was
I'm going to change the law of Pakistan through an ordinance, or rather through two ordinances, and I'm going to think whether this is appropriate or not afterwards.
My Lord,
Is this a submission being made by Mr. Khwaja Haris?
My Lord, I had before the three-member bench used slightly more colorful language and said paragraph 6 is an example of the Wild West. Shoot first, ask questions later. You make a law affecting the entire nation and then say you are thinking about it.
I would like to hear Mr. Khwaja Haris on this.
Whether that ordinance had the retrospective effect or it was prospective.
Which ordinance, my Lord?
The ordinance which the respondent has enacted.
My Lord, they had not talked about retrospectivity, but may I point out?
He has an objection upon retrospectivity, not upon the...
No, everything. He had an objection on a number of provisions, not just retrospectivity. And the defense to retrospectivity very simply was this, that the NAB ordinance itself was with retrospective effect going back to 1985. So the amendments had to be made retrospective so as to have an effect.
Mr. Makhdoom Ali Khan, completely unrelated. Can we compel, since this will be a lopsided exercise,
My Lord.
can we compel Senior Counsel Mr. Khwaja Haris to be in attendance and argue? Is it optional with him, or can we compel him? Because I don't want a lopsided contest. You understand what I'm saying?
My Lord.
I suggest we can invite him as an amicus.
No, amicus, so then he becomes a friend of the court.
Assist. Let him be a amicus this time.
Amicus is neutral.
Isme Makhdoom Saab,
Yes, my Lord.
if my memory does not fail me, then
appeal he will also be entitled.
Amended petition.
then when these ordinance,
No, but in a criminal matter, appoints counsel as well.
My Lord,
Can we, okay, let's put it this way, amicus would be neutrality, which surely he can't be because he's a counsel for one party. But we can appoint him as counsel as well, in addition to what the respondent number one has to say, to assist respondent number one in formulating his submissions. And we can fix the fees for him as well.
if the respondent number one and the learned counsel agree, my Lord,
will,
I don't
will,
know whether
the,
he agrees or not.
will the federal government agrees to pay his fee?
my Lord, the Attorney General will speak for that.
No, whether you agree or not, we can compel you to do so.
It's very interesting, if my memory does not fail me. When these ordinances were promulgated, at that time, the then government, including the respondent, had defended these ordinances on the ground that NAB had caused great damage to the economy and had also violated fundamental rights.
My Lord, your Lordship
And
is...
that is how they had defended it.
Your Lordship's memory is amazing.
No.
I had with my petition filed the press releases and video releases of the then finance minister,
जब वो छोड़िए,
of the then law minister saying the same thing.
लेकिन ये जरा दो ordinances तो दिखा दें हमें, ये जो आपने refer किए इस paragraph में, ordinance 23 and ordinance 26. Is it on the record?
Yes, sir.
If it's not, you can give us photocopies later.
My Lord, I'll give your Lordship the dates and I'll...
No, just show us which pages they are at.
My Lord, National Accountability Amendment Ordinance 2019.
23 and 26 that has been referred to in this paragraph that you just read. Those two ordinances, can you just show?
Yes, my Lord. Actually there were 5 ordinances and I'll draw your Lordship attention to all of them. They are at pages 200 in part 2 of the ICA.
एक second.
And most of the amendments made by the Parliament were in fact based on these ordinances.
Yes, my lord.
200.
Yes, my lord.
Makhdoom Sahab?
Yes, sir.
Some of them, most of
नैब तरमीम कलदम करार देने के खिलाफ सुप्रीम कोर्ट में समाअत इस वक्त जारी है। हुकूमती वकील मखदूम अली खान इस वक्त दलाइल दे रहे हैं। चीफ जस्टिस काजी फाइज ईसा की सरबराही में 5 रुकनी लार्जर बेंच केस की समाअत कर रहा है।
secure the fundamental rights of people who were being wronged.
And I had filed a chart, my lord, to show which amendment corresponded to the recommendations and directions of this honorable court. I had also, and so far as your lordship's other observations.